Good evening and welcome. You're watching the news track. I'm Rahul Kanwal. The Modi government making massive changes to the Indian legal system. What does the Bharatiya Nyay Sahita really mean for you, the citizen? This is the biggest change in Indian laws in the last several decades. How does this impact your life? Are these laws going to make things easier, or is this just a way for the government to try and impose greater control? All that and more in the big India Today Lawyers Roundtable coming up on the news track.
एक ऐतिहासिक निर्णय इस सरकार ने किया है। राजद्रोह को कंप्लीटली हम रिपील कर रहे हैं।
Big revamp of India's criminal laws.
1860, 1898 और 1872 में अंग्रेजों द्वारा बनाए गए, अंग्रेजों की संसद के द्वारा पारित किए गए ये तीनों कानूनों को समाप्त कर आज हम तीनों नए कानून पुरस्कृत करने के लिए मैं आया हूं।
Colonial era laws overhauled. Super boost of criminal justice. New crime code for new India.
ये कानूनों का उद्देश्य किसी को दंड देना नहीं होगा। इन कानूनों का उद्देश्य सबको न्याय देना।
Big changes and their impact decoded. Big focus on News Track.
Before I get into the Lawyers Roundtable on the new laws, let me take you through the headlines I'm tracking today. Maha-Aghadi split wide open after Sharad Pawar meets his nephew Ajit again. Pawar Senior dismisses reports of him joining the NDA. India gives China another big headache. Frontline airbase in Ladakh's Nyoma gets a new life. This is an India Today exclusive newspaper. Over 50 dead in the last 24 hours in the Himachal rain rampage. Several still trapped after a Shiv temple collapses in Shimla. Shocking double suicide in Chennai. NEET aspirant's father dies by suicide days after his son's death. Politics erupts. DMK blames the BJP and the government. Gali politics erupts again after calling pro-BJP voters monsters. Congress Neta Surjewala attacks Prime Minister Modi, says he is an asura.
अरे राक्षसों, भाजपा जजप्पा के राक्षस हो तुम लोग। भारतीय जनता पार्टी को जो वोट देता है और भारतीय जनता पार्टी का जो समर्थक है वो राक्षस प्रवृत्ति का व्यक्ति है।
The Modi government has introduced a massive revamp of India's criminal laws. It's a new crime code that is supposed to be refined and ensure speedy justice. Changes have been made to the laws on sedition, gang rape, mob lynching, and a gamut of other issues. What are the key changes that the three new laws entail? And most importantly, how do they impact you? Law Today tries to decode the changes that are now on the anvil.
In a surprise twist at the end of the Monsoon Session of Parliament on Friday, the centre completely revamped and replaced three historical laws that were the backbone of the criminal justice system in India. The Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act all stand to be replaced with new laws.
राजद्रोह पर ये अंग्रेजों ने अपने शासन को बचाने के लिए एक कानून बना था। मैं इस सदन को कहना चाहता हूं, एक ऐतिहासिक निर्णय इस सरकार ने किया है। राजद्रोह को कंप्लीटली हम रिपील कर रहे हैं। यहां लोकतंत्र सबको बोलने का अधिकार है। राजद्रोह को हम कंप्लीटली रिपील कर रहे हैं। मान्यवर, गैंग रेप के सभी मामलों में 20 साल की सजा या आजीवन कारावास का प्रावधान किया है, जो आज नहीं है। 18 वर्ष से कम आयु की बच्चियों के मामले में मृत्यु दंड का भी प्रावधान। मॉब लिंचिंग का बड़ा शोर मचा है, हमने उसको केयरफुली करा है। मॉब लिंचिंग के लिए भी 7 साल आजीवन कारावास और मृत्युदंड तीनों का प्रोविजन कर हम प्रावधान मान्यवर लाए।
Here's how the changes are likely to impact the common citizens of India. The new law allows for registration of an FIR in any police station, irrespective of where the crime is committed. It also allows citizens to file e-FIRs. The police will have to maintain a proper system of sharing information via establishment of a police control room. Once the charge sheet is filed by the police, the court has a 60-day window to frame the charges in the case and begin the trial. Once the trial in the case is completed, the judge is duty-bound to pronounce the verdict within 30 days. Not only do the new bills propose more stringent punishments in case of rape and gang rape, they also attempt to ease the legal process for survivors of sexual assault. The statement of a sexual assault survivor would now be recorded in her home by a woman magistrate in the presence of a woman police officer. The law also makes it an offence for anyone to disclose the identity of a survivor of sexual assault.
Is it an overhaul? Perhaps not entirely. Is it an improvement? Hopefully, yes. But is there a lot to be done? Yes, there is still a lot to be done. Speaking for myself, what I would have envisaged as an overhaul, which is essential now for the criminal justice administration in this country, is to have all your central criminal laws in one code. Everything. Make it facile, make it logical for the investigator, make it logical for the practitioner, and make it logical for the judiciary.
Now, the not-so-good changes. As the law stands currently, any person who has been arrested can be sent to police custody only for a maximum of 15 days from the date of arrest. In the proposed law, however, the powers of the police to seek police custody have been expanded, where the police can now seek this 15-day custody at any time within 60 to 90 days of the arrest, depending on the offence. There is no relief for a common man when it comes to a grant of bail and enforcing. Bail is the rule and jail is an exception through means of proper law. No new options for default bail has been given, except for under-trials who have served at least half their sentence. The new law allows the court to proceed with the trial if 90 days have elapsed since framing of the charges, and the accused has still not appeared before the court. The new law explicitly allows digital devices such as phones, laptops, etc. to be seized during an investigation. Emails, messages, server logs, location details will all be included as part of electronic evidence admissible in a court of law. The massive legal upgrade will replace colonial-era criminal laws, a new refined, speedy and people-first crime code for New India. With Nalini Sharma, Bureau Report, India Today.
So what does this Bharatiya Nyaya Sanhita or the new IPC mean for you? How does your life change? Remember, these laws impact every one of us. Are these genuinely a step in the right direction? Do they simplify the old cumbersome legal procedure, or does it just allow the government to play Big Brother even more so? Joining us on the news track, I want to welcome Aman Lekhi, senior advocate in the Supreme Court. Siddharth Luthra is with us, another senior advocate, former Additional Solicitor General of India. Sanjay Hegde joins us as well, senior advocate in the Supreme Court, and I'll be joined by Abhishek Singhvi in just a moment. I have Nalini Sharma, she heads India Today's Law Today division. So I want to go across to Aman Lekhi first. Most people watching at this time would not have had an opportunity to go through the commas and the full stops of the new law. From what you've gathered and from what's in the public domain, Mr. Lekhi, could you lay the context for this debate by telling us whether you think the changes in the laws taken together are a step in the right direction, and if so, to what extent? Let's start from there. Aman Lekhi.
Well, I find the Home Minister maligning the existing system, slandering it and running it down, which in my opinion is completely unwarranted. It's a very simplistic assertion based only on one aspect of the Penal Code, that is 1860, to say that it's the colonial legacy. It is not a colonial legacy because insofar as the method of criminal administration is concerned, there are certain standardized approaches. There is an adversarial method and inquisitorial method. As far as the Indian law is concerned, it's got elements of both. While combining elements of both methods, there are certain constitutional values which are present. The constitutional values affirm individual liberty. We have in our legal system presumption of innocence. We also have in our legal system a right to silence. We have an open adversarial system. We have open courts. And insofar as the administration is concerned, that is modern and the jurisprudence is current. So for the Home Minister to say that it's a revamp because we are undoing a colonial legacy shows a complete disconnect with reality, which is completely unwarranted. And it needlessly disparages the system and will create some kind of view about the existing legal system to create some unrest about it, which in my opinion is completely unwarranted too. I also feel that the method in which they brought it about is unthinking. I'll give an example where this is concerned. You have mentioned two things in this. I just happen to read whatever I read in the newspapers. One, mob lynching. Mob lynching is punishable with 7 years imprisonment. Mob lynching is murder. It's an aggravated form of murder. And mob lynching is concerned, you don't only look at the people indulging in mob lynching, you look at the people responsible for enforcement of the law. We will deal with bystanders, deal with others. It's an aggravated form of murder. For an aggravated form of murder, you have a less punishment. You talk about sedition. I'm very much in favor of sedition, but that's not an issue right now. Sedition has the expression subversive activities. Subversive activities along with secession and other activities. Now, subversion is an element of secession. If you have subversion apart from secession, what will subversion contain? So it's an expansive definition which enlarges the scope of interference which is there in involvement. As far as aspects are concerned, the method in which this has been brought about, I have a very strong reservation that is concerned. If this is well thought out, it should have been in the list of legislation which the government should have brought. It shouldn't have been part of the supplementary legislation. So what does that show? I feel that is an attention diverting device because you bring a bill, the bill is not law, the bill goes to standing committee, the standing committee's recommendation is not binding on the parliament, the matter goes into limbo, we are discussing something which is not the law today, which will never be the law, and the law which stands today is discredited. This is no way how a government should work.
Wow, those are strong, scathing opening comments from Aman Lekhi. Let me go across to Sanjay Hegde. You're saying it will never be the law. I wonder why you say that. I'll come back to you in a moment. Let me just get some opening comments from everybody else as well. Sanjay Hegde, you just heard Aman Lekhi taking apart the very premise behind which this law has been introduced, saying there was no need. The fact that the Indian legal system as it stands is cumbersome, and while Aman Lekhi put up a strong defense for the way things are, many watching at this time would agree that if things are simpler, faster, speedier, more effective, justice would be better served. What's your view on the manner in which the change is being brought and the need for the change and the extent to which, once and if these changes are implemented, the legal system, will it be better than the past?
Well, firstly, I do agree with Aman that this has been brought suddenly. And for that, the best proof is the draft itself. It's an incomplete draft full of legislative howlers. Your basic question on sedition. Sedition has been replaced with Section 150, acts endangering sovereignty, unity and integrity of India. Now, if I were to read it out, for instance, or by electronic communication or by use of financial mean, when you actually mean means by financial means, then you have an explanation which is entirely which is incomplete. Comments expressing disapprobation of the measures or administrative or other action with a view to obtain their alteration by lawful means without exciting or attempting to excite the activities referred to in this section. Full stop. Do not come within the mischief of this section, or you say that this is not covered. Incomplete sentences, half-written wrong words, and they are galore. There is a plagiarism device called Turnitin, which lots of law schools use. Somebody ran put this on Turnitin, and 83% of it is copied from the existing Indian Penal Code. What has happened is a shuffling of sections. The 17% which you've changed, you might as well have brought in an amendment act to the Indian Penal Code. I don't know what the reason was. You wanted to have something called Bharatiya, something this. Fine. Have a vision. whatever work you submit to Parliament, please have the decency to submit a complete draft before it goes to the parliamentary committee. It looks like a half-complete draft was suddenly pulled out of the legislative department and shoved down Parliament's throat. Now let me tell you why Aman says that it may never become the law. It now goes to a parliamentary committee, and the parliamentary committee obviously will have to put all this together. Now there are maybe 2 or 3 sessions of parliament, of this parliament. This is an act, these acts have been brought in the Lok Sabha. By the time it comes up for passing in this Lok Sabha, we do not know whether it will happen or not. Otherwise, this will lapse. If it becomes the law, then also people have warned about not only such an overbroad section of subversive activities, all this that I've told you so far could very well qualify as subversive activity. So we are going to have a generation of lawyers and judges breaking their heads over something that could have been avoided with a little bit of care at the legislative stage.
Okay, let me get Nalini's perspective on the reasons that the government has stated for bringing this law. Now, I understand both from Aman and Sanjay's perspective, everything that they've learned, all the sections that they know and have referred to as second nature now need to be unlearned and relearned. That's irritating and complicated. But from the government's perspective, what is it that they're hoping to achieve, Nalini?
Well, Rahul, whatever is it that the government is hoping to achieve, I don't understand why it could not be done by way of an amendment. So that the things that were there in the existing IPC, CrPC, like Mr. Sanjay Hegde says, that almost 85% of it has been picked up from the existing laws. So the changes that the government wanted to bring about could have been done by way of an amendment, which would have made things easier, not just for the lawyers who, like you correctly said, will have to unlearn and relearn, but also for the judges. Every time that a lawyer now references to a particular section, the judge might not know what he's talking about. He'll have to go back to the bare act. He'll have to see what section it is. So instead of the objective of the government, which is to expedite the proceeding, it might prolong the proceeding even more, because there'll be a significant time that both the bench as well as the bar is going to take to get accommodated to this.
Okay, let me get Siddharth Luthra's take on this, all these changes which are being described as a massive overhaul of the judicial system, legal system. We are hearing 2 top lawyers say that it seems to have been brought about in haste, may not actually see the system being improved, seeks to discredit the system. Where do you come out on this, Siddharth?
This exercise has been undertaken for a while, and there has been an attempt to make the Indian Penal Code a little more comprehensive. They've added terrorist offences, corruption offences, snatching, organized crime. And they've taken the definition clauses and they've put them in one provision to make it perhaps easier to read. What I find on a reading is some of the illustrations also and examples have been updated. But what I find is that essentially it is a reworking of the time and tested code. Other nations have also done this exercise. So the Indian Penal Code as it stood has been used as a template which has been modified by other nations to perhaps domesticize it a little. It has been spoken of to, to get rid of the colonial legacy. But if you look at this substantively, let's look at the definition of, let's say, culpable homicide or murder. It's substantially the same. Hurt, grievous hurt is substantially the same. And some concerns of the legislature in terms of additional offences have been added. So that's so far as the Indian Penal Code is concerned. Then you have, for me, speaking for myself, one of the concerns that arises from this is that by adding organized crime, by adding terrorist offences, by adding corruption offences, you are bringing them in this code, in this Sanhita, but you are not removing the provisions or the laws which contain these. That is, for example, Maharashtra Control of Organized Crime Act. You've not removed the Prevention of Corruption Act or the provisions in the Unlawful Activities Prevention Act. Then again, Unlawful Activities Prevention Act offences are investigated by NIA. So there is going to be a peculiar interface between this legislation and the NIA Act, and that is not being dealt with in the procedural law as well.
Okay. Aman Lekhi,
So
one of
far
the
as
things which was said was that sedition has been done away with. But if you see the fine print, provisions which amount to actually dealing with offences similar to sedition still exist even in the new law. So is it actually doing away with sedition, which is what the government had publicly said it intends to do? Is it just finding another way of inserting virtually the same provisions without calling it sedition? Aman Lekhi?
You see, sedition, it's amusing to read that particular provision. It's hilarious. It just shows the lack of seriousness in drafting important provisions and complete want of professionalism and understanding both of law and language. There is a grammatical error in it. The semicolon is at a place it shouldn't be, and apart from the fact that the English is wanting altogether, the most substantial issue here is the use of the expression subversive activity, which I said at the beginning. Now, what is subversive activity? Subversive activity can have a very wide connotation. It can be open, it can be secret, it can be violent, it can be peaceful, it may be ideological, it may be political, it may be criminal. What is subversion? The subversion, you go to read the mind of the person who is invoking the law, or this is an objective standard by which apply the law. If you want to substitute a provision by another provision, you have to set out the standards for the purpose of application of that provision. And then that is the prime obligation of a penal provision, so as to put people to notice as to what kind of culpable conduct will actually be recognized as punishable. If you look at this particular definition, it lacks that particular direction altogether. I don't joke when I say it's the poor English. Point is, that's the language in which the offense is drafted, and therefore the means to understand it. Both in law and in language, this position is wanting. Now here, the duplicity of the government becomes obvious. The government was very keen, and rightly, I am in favor of sedition personally, I may be in minority, I think sedition is necessary for a country, but be that as it may, that's aside. The government defended sedition. The government said that sedition is necessary. Now when you bring about this particular change to alter the law, in my opinion, there is no need to alter the law itself. For public acceptability, you say that sedition is diluted, but the provision which is there expands that particular offense, and while expanding the profession is without the limitation and the protection of the old one. So we're in a worse situation now than we were earlier.
Dr. Abhishek Manu Singhvi joins us, senior Congress leader, one of the top jurists in the country. Dr. Singhvi, you know, we are hearing from the likes of Aman Lekhi, Sanjay Hegde, Siddharth Luthra, raising questions about the manner in which the new changes have been brought about and what this means for the legal system. As a top jurist, if you try and put your political hat on the side for a moment, do you think that these changes actually simplify, de-jargonize and potentially speed up the Indian judicial process?
There is somebody competing in the voice system with me, Rahul, but that apart, I think I would hate anybody to speak in a broad, blanket political manner on a matter like this. It requires a nitty-gritty analysis. Let me say at the outset, anyone and everyone, including myself, is really giving a more superficial and tentative view, because here you have three big acts, one totaling 356 sections, another 533 sections, and a third 170. To be able to compare the changes of the current with the old, to be able to analyze them and to give you a very good analytical, comprehensive answer, I think is beyond the reach of most, including geniuses, and I don't pretend to be one. So I think we must be very careful, and I think it must await a more detailed analysis. I'm writing an article on this also in the near future, which will be a little more pointed and better than today. But having given that disclaimer at the outset, can I tell you three or four points which I think stare you in the face and don't make very good reading? And I have nothing to do with politics when I speak about three acts. First, I am very disappointed at one thing. I don't think it has struck anybody that a change, if it is done for minor things or just for the sake of change, of such a nature, after all, one of them tinkers and touches 175 sections of the old IPC, the Bharatiya Sanhita, the Nyaya Sanhita. It touches and amends little or more 175 sections. The CrPC counterpart, the Nagrik Suraksha Sanhita, touches 160. and the third one touches almost 23 or 30, the counterpart of the Evidence Act. Now, the point I'm making is when you tinker with existing statutes, you lead to an explosion of litigation. Unintended, unplanned, unanticipated, unforeseen. Everything in the past technically gets erased. Each section has 100 case law. Now it is open to clever lawyers and even cleverer litigants to say that established judgments, established jurisprudence should be ignored, and you should reinvent the wheel and decide de novo because the section is new. You cannot imagine the kind of explosion of litigation this will lead to, a thing which is completely forgotten, point one. Point two, sedition is a big, big disappointment. Indeed, I would say it's a fraud on power. I just heard some of my friends in the last part, but I would like to add to what they are saying. The section, and I will not read it to bore your viewers, I've got it in front of me. It was earlier challenged and a statement was made in the Supreme Court that for the time being we will not activate it, we will not use it. Now, the version you have now is far vaguer, far broader, and far more all-encompassing, which are the three precise reasons why this whole crusade against sedition was on in our country, and which is the reason why the Supreme Court was about to give a stay, but desisted when the government said, for the time being, we will not act on this existing 124A. Now, this is actually a fraud on power because this is very vague, apart from all the grammatical and the English errors. I am saying that this is really not bringing in sedition from the back door. It is enhancing and enlarging sedition with many more unintended things, giving it much more power, and shows the mindset of what I call at the moment a clear control freak impulse. And they've done it very surreptitiously, in fact, over cleverly, disingenuously, while on the left side pretending not to do it, on the right side actually bringing in. The Home Minister specifically made a statement that we've done away with sedition. Well, that may be technically true, but a half-truth like Ashwathama Hatto is much worse than a lie.
Can this be taken, Dr. Singhvi, as a first draft which then goes to the Parliament Standing Committee where it gets refined, and by the time it comes to Parliament, like with the privacy law, some of the concerns raised by privacy advocates, members of the opposition, are factored in? While it may still not be perfect from the opposition's point of view, from the legal fraternity's point of view, it's better than what the government has tabled at the moment.
Well, you're certainly right. That's the theoretical and practical object of committees. I have myself been and am now the chairman of a parliamentary standing committee and have been of two earlier. There is a greater degree of convergence and unanimity. Select committees are even broader. But the point is, ultimately in today's divided atmosphere, you realize, can you hear me?
I hear you well. Go on, please.
You realize as much as I do that political division means a lot of things go by majority. And the majority on this is of the ruling party, and there are instructions, I know for a fact, in parliamentary committees not to go against the political line taken by the ruling party. I hope and trust what you're saying is true. But that brings me to my other 2 or 3 points very quickly, Rahul. One is, what was the level of consultation before such a wide-ranging set of provisions and acts? You are told that in 2020, in the middle of COVID, a 4 or 5 person committee, all males, no diversity, no females, was constituted. Their public consultation after 2020 for 1.5 years of COVID thereafter was zero. Nothing is public. You're not told. And you're not told the recommendations of the committee also. You're not told what was the degree of consultation. Normally, on this kind of issue, you would have 2 or 3 law commission reports, one each on one of the each of the code which you're talking about. There is no law commission on this. And a committee is quickly set up, shrouded in secrecy, and you are told that you've consulted just because 2020 to 23 has passed. My other point is a very retrogressive thing which has gone through, which I don't know if you've noticed. 15-day police remand is now, I am told, in the nature of 60 or 90 days, depending on the offense. You already know what is happening, Rahul, in terms of remands, police custody. You already know the kind of things happening, extraction, pressures, harassment. 15 days has stood the test of time. You should make it 14 days, not 60 or 90. I don't understand how it is. Now, there are, of course, some good things. I think the community service part is a good move. I would like it to be enlarged and expanded beyond petty offences.
No, but it doesn't explain, from what I've gathered, what a community service would actually entail, which could potentially mean that different judges could read it in different ways, and we could have all kinds of things happening in the name of community service.
So I was coming to that. Devil and God both lie in the details. I hope and trust that the rules will flesh it out. I'm only saying in principle this is a good thing, but it doesn't mean that you can allow it to be, its broadness and its vagueness to be exploited by vested interests so that you get easy community service and I get rigorous imprisonment. You know, this is the kind of thing which has to be fleshed out, but in principle it's a good move. Mob lynching, in theory, is a good provision, but then you have to realize that it depends on fair prosecution. It depends on social construct. You see the statistics, Rahul. Mob lynching as a fact of life has increased exponentially since 2014 in numbers. What does it lead to? By its very nature, it does not lead to fair prosecution. Certain people have the upper hand. So there's no point making a nice sounding provision which in its application may lead to acquittals or not real prosecution or catching hold of the victim rather than the perpetrators. These are realities which we have seen in the last few years. And I hope and trust that this will go through a very, very careful, close scrutiny, not merely by party majorities, and at least a large part of it will be sanitized and addressed when it comes back to Parliament.
Okay, I leave it with you over there. Thank you very much, Dr. Singhvi, for joining us. Sanjay Hegde, can it be said from the government's perspective that here is, I don't want to say a cabal of lawyers, but like a community of lawyers who are used to the system being a certain way, and therefore to protect their own interests, they're taking the position that they are?
There's nothing, listen, most of us lawyers will have armies of other lawyers under us to tell us what to say.
No, but Team Sodo is no longer Team Sodo and 420 is no longer 420. So there's a lot of relearning involved as well.
That's okay. We can learn fast enough. The question is, as Dr. Singhvi put it, a whole host of precedents which define what murder is or what is to happen in a given circumstance. Now, please look at it. When, for instance, I'll give you, when do you file an application for discharge? You file an application for discharge after the evidence is put in, and you say that the evidence doesn't make out a case. Now, what does the new Samhita provide? The accused may prefer an application for discharge within a period of 60 days from the date of framing of the charges. Now, that is some kind of, what shall we say, put the cart before the horse or after the horse. The court says that there is material to frame charges against you. After that, you go and file an application for discharge, and then the court gets into that. This is, I think that if they had run their drafts through teams of lawyers, we would have volunteered for national service, saying, boss, look, this is the problem, here is the problem, why don't you come back? It appears that a few consultants were hired, somebody was told to draft it, some kind of general consultation happened, and they possibly thought that there were going to be more consultations. But now a half-baked draft has been thrown into the nation's face, and we are told that, look, forget Macaulay, you Macaulay Putras. Macaulay drafted the IPC, therefore it is bad. Sometimes I'm reminded of what Shelley said, that poets are the unacknowledged legislators of mankind. We had a draft, we had the IPC, which was a model, as somebody else said, for several countries. The IPC is common to most of the sections between India and Pakistan, as far as the penal code are concerned, are very common. This is part of our heritage. This is part of the legal system. Yes, procedurally, certain things have been sought to be improved, but even there, I showed you what's happened on the discharge provision.
Okay, Siddharth Luthra, how do you respond to all the criticism that we're hearing? This is some kind of black magic had the government pulling this out without adequate discussion and deliberation, that this is being done in a hidden and opaque fashion. How do you respond to this criticism, and what do you think can be done to try and make the changes palatable and acceptable?
I think these are questions parliamentarians should answer, and it is a debate between different political entities. I am not competent to answer such an issue, but the point is this: to have meaningful reform, there will have to be discussion, and I am hopeful that now the matter has gone to the standing committee, there will be meaningful debate and consideration, and what will come back from the standing committee will be a much improved version. Look, any change in the law, any change in the procedural, substantive or evidentiary law is important for the evolution of a nation's criminal justice system. But I feel that this administration had a golden opportunity and they could have done a lot more. I'll leave it at that.
But Aman Lekhi, some of the things that have been sought to be introduced, for example, witness protection, are changes that the Indian legal system has been clamoring for a long time. And is there a way in which we can implement the reforms which are genuine steps in the right direction and try and address the concerns as well, find a happy middle ground? Is that possible in your view?
No, absolutely. But you don't need to have wholesale a repeal of the existing law, demeaning of their worth, and suggestion that this is a liberating exercise. I have my very serious objection, and I will not in any way hold back on my criticism, like Siddharth is saying. I think this requires all-rounded, comprehensive and trenchant criticism of the government. As far as reform is concerned, it's not the first attempt at reform. There have been various committees. We have law commissions also in place. We have got judicial determinations wherein the courts have also pitched in, talking about changes that have taken place. To bring about changes, law is dynamic. It's open to reform and interpretation. It is open to modification. There is no objection to that. But the point is, the process has to be measured, and the test is of legitimacy is not just a vote in Parliament. I have got a very strong objection that is concerned. It is reduced to a vote in Parliament, whether through the standing committee method or legislative measures. This is a comprehensive legislation, the core of the penal system. Insofar as the change has to be brought about, the change cannot possibly be through 3 bills surreptitiously brought at a time when we were discussing other issues of national importance. If matters of this import are to be brought, they have to be debated prior and later, not kept and sent to the standing committee and just kept on the shelf for the time being. It just shows that the purpose is not reform. The purpose is distraction. You are all discussing something which is not the law. We are discussing something which may never be the law. And while discussing that, we are not discussing something which should be relevant to the current situation. So the question I'm putting to myself is, if it's a matter of this importance, why was it presented in this particular manner? Why was it shelved by sending it to the committee? And was the real objective actually reform? Or the objective behind that was simply a diversion? Because it seems more of a diversionary tactic than a realistic attempt at reform.
Okay, Nalini, what happens next? This goes to a standing committee. Does it come back in time for the winter session? Because one of the concerns is whether this will come back before the next general election at all, because then you have the budget session, which is a truncated session, and then there are elections. So do we have a timeline for what happens next?
Well, the government is certainly hoping that it's going to come back in time for the winter session.
But can it, because of the disagreements, the kind of consultation that will be required for bills of this magnitude?
Well, in my opinion, possibly not, because there's going to be a lot of pushback, mainly because there were no consultations that were really held before this law was introduced. So there's going to be a lot of pushback from within the legal community against these laws and against the changes that have been introduced. In addition to that, in case this law is now challenged before the Supreme Court, even if it comes by the time of the winter session, if it's challenged before the Supreme Court and the Supreme Court starts looking into the matter, then it might go on for a much longer time than what we expect for. But the reason why there are certain aspersions that can be cast on the government's intent over here is because there was, like somebody stated, they had a lot of golden opportunity to make changes, especially with regard to very real problems that India has been facing. They could have brought in a law against hate speech, which has become a flashpoint just in the past few months. But we've seen no law on hate speech, despite the fact that they say that they've brought in a law against mob lynching. We see no law on the aspect of grant of default bail, despite the fact that the government acknowledges that prisons are overcrowded. There are a lot of people under trials who are still locked in the prisons.
You know, the reason I set up this roundtable is to pick some of the minds of the finest lawyers on where they stand on the current laws. Remember, we also reached out to a lot of the lawyers in the BJP. None of them for this show agreed to come. However, as this debate builds, hopefully we will hear from the government. They can explain their perspectives. For the time being, you've heard from the likes of Aman Lekhi, Sanjay Hegde, you've heard from Siddharth Luthra, Abhishek Singhvi. Nalini and her team will track these changes very, very carefully. This requires a conversation because these are massive changes. They impact every one of us. They impact the Indian legal and judicial system as it stands. And as you heard, a lot of the past judgments and the context in which that they've been given, what happens to that going forward. So a lot to chew on. These are big changes. Can they be pushed through? The government has sent this to a committee, so it will be debated. We'll track what happens there. I want to thank all of you for joining us on the news track. The 19th round of India-China co-commander talks have concluded in Chushul. And while both sides discuss disengagement in eastern Ladakh, India has given China another major headache. A new Air Force base in Neoma at over 13,000 feet. The new air base can operate fighter aircraft, radars and upgraded drones for enhancing surveillance in the Ladakh sector.
Into the India-China standoff in Ladakh, India is ready to put China even more on notice. From modern weapons to infrastructure, the Modi government is leaving no stone unturned now to check Chinese expansionist designs and pile the pressure on that country. As part of an India Today national exclusive, we now tell you about a new fighter aircraft base is now emerging where an old helicopter base once stood in Neoma, very close to the frontier with China. Ever since the 2020 June Galwan clashes in which 20 Indian soldiers and an even greater number of Chinese soldiers were killed during a violent confrontation, India has consistently increased its deployment in restive Ladakh. The Indian Air Force has revealed how it has been swinging into action, pressing its transport aircraft fleet and deploying over 68,000 troops to forward locations and airlifting 90 tanks, 330 infantry fighting vehicles and several artillery guns over the last 3 years. The Indian Air Force has also airlifted critical assets like radars and surface-to-air guided weapon systems to the Ladakh frontier. The deployment of troops, tanks and ammunition continues as a complete de-escalation or de-induction has not happened in the Ladakh sector.
While there have been no ugly face-offs or clashes between Indian and Chinese troops in eastern Ladakh, tensions continue. While a military dialogue continues, India is making sure that slowly its capabilities enhance in the forward areas. And now a fully operational fighter aircraft base is coming up barely 50 kilometers from the line of actual control. At more than 13,000 feet, India will make sure that its fighter aircraft can operate and respond quickly to any Chinese aggression.
New additions to these assets are being currently made. The Indian Air Force has inducted its latest Heron Mark II surveillance drones, which can carry out both strike operations as well as extended surveillance operations on the frontiers with China and Pakistan.
Indian Air Force has received its Heron Mark II drone, which are seen as game changer in drone flying in the country's security needs. The drone, which can fly for around 36 hours, can cover the entire length and breadth of India's boundaries with both China and Pakistan, has given a strong capability to Indian Air Force.
Meanwhile, the 19th round of Corps Commander level talks on Monday continues to aim to resolve the ongoing military standoff between the two nuclear neighbors. India is pressing for disengagement of the Chinese army from Depsang in the eastern Ladakh frontier. Military talks come ahead of a likely meeting between Prime Minister Modi and President Jinping at the BRICS Leaders Summit in South Africa next week. With Manjeet Negi in Ladakh, Bureau Report, India Today.
A day after 17-year-old NEET aspirant Jagadishwaran died by suicide, his father was also found dead at their home in Chennai. The twin suicides have triggered a massive outrage. Tamil Nadu Chief Minister has blamed the BJP and the state governor for these deaths.
A tragic double suicide in Chennai of a father and son that's numbing India. A teen medical aspirant took his life, leaving his father shattered with nobody left to live for. The father also died by suicide 48 hours later. 19-year-old Jagadishwaran was reportedly depressed over 2 failed attempts to pass the competitive NEET exam, and so took his own life at his house in Chennai. His devastated father broke down when he spoke to the media soon after, with an appeal to the government to immediately block NEET in Tamil Nadu as they had promised.
The repeat ஒழிச்சாதான் எல்லா பசங்களும் நல்லா இருப்பாங்க. ஐயா ஸ்டாலின் ஐயா வந்த உடனே முதல் வாக்குறுதி அதான் கொடுத்தார். குழந்தையெல்லாம் காப்பாத்துறேன், நீட்டை கேன்சல் பண்றேன்னாரு. இது வரைக்கும் எதுவுமே பண்ணல. என்ன மாதிரி நிறைய சிங்கிள் பேரண்ட் எனக்கு வந்த மாதிரி எந்த அப்பாக்கும் எந்த குழந்தைகளுக்கும் எதுவுமே நடக்கக்கூடாது. அது முதல்வர் ஐயாவும் உதயநிதி ஐயாவும் தான் பேசி கனிமொழி அம்மாவும் பேசி தான் அதை தீர்த்து வைக்கணும்.
2 days later, the father was found hanging too. The tragic news has sparked a NEET debate once again in Tamil Nadu. Chief Minister M.K. Stalin expressed his condolences and urged students not to take such drastic action.
The unfortunate deaths of Jagadishwaran and his father Selvashekhar by suicide, allegedly due to NEET, has shocked the entire state. The Chief Minister has decided to boycott the Independence Day reception to be hosted by Governor Ravi, and says that even after 77 years of independence attained by our ancestors, he still wonders if this freedom is for everyone or for a selected few.
மிகவும் கண்டிக்கத்தக்க ஒரு விஷயம். ஒன்றிய பாஜக அரசு ஆனால் இதையெல்லாம் வந்து காதில் போட்டுக்காம மாணவருடைய வாழ்க்கையில் விளையாண்டுட்டு இருக்காங்க. ஆரம்பத்திலேருந்தே நம்ம சொல்லிட்டு இருக்கிறது நீட் தேர்வை ரத்து செய்யுங்க அப்படின்னு தான் கேட்டுக்கிட்டு இருக்கோம். 2 முறை சட்டசபையில் தீர்மானம் நிறைவேற்றி அமைச்சிருக்கிறோம். இங்கே இருக்கக்கூடிய ஆளுநர் வந்து தமிழ்நாட்டு மக்களுடைய மனநிலையை பற்றி எதுவுமே தெரியாமல் நம்முடைய திராவிட முன்னேற்ற கழகம் ஏற்கனவே சொன்ன மாதிரி தொடர்ந்து சட்ட போராட்டத்தை நடத்தும்.
Udayanidi's visit to the hospital was marked by protests as Jagadishwaran's friends surrounded Stalin's son, demanding answers. The BJP and DMK are now trading barbs over the NEET exam, as the DMK blames the governor for stalling the anti-NEET bill. Remember, the governor just 2 days ago, while interacting with NEET toppers, made it clear he would never sign off on an anti-NEET bill.
Going to the president because it's a subject of concurrent list. It is a subject on which only the president is competent to give the clearance. But given to me, I shall never give it this year. Why? Because I like my children to go, and I tell you for sure, there are many students who are doing it without coaching.
This unfortunately hasn't been the first such tragic NEET-related suicide, and it's always been followed up by a whole lot of empty promises on banning NEET. But is it time to have a conversation rather than the need to counsel students and provide them with the necessary psychological help to overcome failure in their life rather than take the extreme step? With Pramod Madhav in Chennai, Bureau Report, India Today.
This is where we wrap up the news track tonight. For your time and your trust, thank you very much. I look forward to seeing you 8 p.m. tomorrow evening. Till then, from all of us here, goodbye, good night, and here's wishing all our viewers a very happy Independence Day.